referendums and initiatives in the zoning and land use process. This has been referred to several times today and yesterday by others in other panel discussions, and it seems to be a topic that keeps coming up. It's something that we scheduled for this conference because of some pending issues, and we'll talk a little bit more in detail about those, but we anticipated that we would have some more recent court ruling, a particular court ruling to talk about, and talk about the implications of it. So far, that court ruling hasn't dropped, so we're going to have to tap dance and talk about some other things, but it seems like there's plenty to talk about. As you look at the slide that's up on the screen right now, you may notice that we have indeed created a new law firm, Summercorn, Godfrey, Deal and Budge, and it's great that I get the top billing because I am not an attorney. Does that? Cameron never fails to remind me I'm usually the oldest in the room. So with that in mind, I'll just begin this discussion by going to that very thing back when I was in graduate school many years ago. But I was really fascinated by the land use law class, which was the required course that I took in my master's of urban planning program where I was at. I really found that to be interesting. And I really found the whole process of how land use regulation came about in the United States and how everything worked was how it really all just came about and kind of worked, and the standard enabling acts. When I came back to Utah and started working here as a planner and looking at local codes, the local code where I was working or the communities I was working in, and then the relationship, then I started looking at the state code. Not a lot of people were paying much attention to the state code. And I would look at some of our local codes and say, I don't know if the state code really allows us to do this. Is anybody paying attention? And there really wasn't a lot of attention being paid to that. It was also clear that, that over the years, because that Standard Enabling Act that was developed and used all around the United States to enact land use regulation came about in the 1920s. And Utah did adopt that for cities in the 1920s. And Salt Lake City was the first community in the state in the 1920s to adopt a zoning code. But then it was also adopted for counties in the 1940s. But in that whole period of time, every so often there would be some amendments made to that land use act, Standard Enabling Act that was in the state code. And as I was looking at it, and this is now in the mid-'80s, it was hard to follow. It was really kind of hard to read and understand and follow because it kind of been messed around with and changed a little bit, and nobody was really paying a lot of attention to it, as I mentioned. Well, when I came back and started working in the state of Utah, it was the early '80s, and we were in a recession, and there wasn't a lot of development going on. In fact, there was even a fear that people were kind of leaving the state of Utah. Can't imagine that now, but that was really kind of the case. So there was not a lot of development going on and not a lot of attention being paid to the land use process. But that picked up and changed in the 90s. So much so that it became clear that if we were going to resolve some of these issues that were beginning to crop up with regard to the development process, that changes needed to be made. And so that was when an effort was done in the 90s. And we wound up with the Land Use Development and Management Act, or LUDMA, as we call it now in the state code, and various other things. And the process kind of evolved as we learned, and we kind of learned from experience, and the development process and the growth in the state of Utah was generally just going great guns and fast. And we kind of developed how this whole thing is to work. And we kind of evolved into this whole administrative, legislative side of things and what's what and how the process is to work. But there was always this kind of outlier there. And that was this thing called a referenda, a local referenda, which was authorized by the state constitution. And started seeing some of those things begin to happen in the 80s and then more so in the 90s. And it really kind of seemed to turn the whole process on its head, or it wasn't really clear what it would do to the process of land use. But one thing that was kind of obvious was that it was really going to affect the time frames, or could affect the time frames on which development may occur because of the process that an applicant, a property owner, or a developer would go through and expect some kind of a resolution of that, and then by doing a referenda, that process could be really disrupted and almost be unpredictable in a lot of ways. And so there was a period of time where there was a little bit of back and forth. Things would get taken to the courts. The courts would make some ruling on something. Then we'd go to the legislature and would change something with regard to the referendum process in the legislature, and then back to the courts, and kind of back and forth and back and forth. And it wasn't really very clear how this was all shaking out. It was definitely changing, but it wasn't really clear how it was changing. It was going to shake out. But there still weren't a lot of referenda, so it really still didn't seem to be something that a lot of people were worried about. But I and others were saying, you know, when you look at what's happening in other places around the country, particularly California, and as much as, you know, when Dave was up here, Dave Milheim later, and he said, don't Californicate Utah, as much as we always desire not to be like California, we always seem to become like California. And California had taken the whole referendum process to incredible new heights. And it was just amazing to watch what was happening there, to the point where individual developments seemed like in some communities, almost every development project had to go through some kind of a referendum process. And I think many here were saying, yeah, we really don't want to see that happen here. But there were those of us who were predicting that unless something really changes or happens, I think our citizens are going to discover the process, and it's going to happen here more and more. And we may yet become, once again, much like California in the development process. Well, with our incredible growth over the last few years, and we have begun to see an uptick in the referendum process. If I can just reference a few communities from the last year or so: Holiday, Orem, Harriman, Salt Lake County. Just a few places where referendums are either taking place or have been threatened and have affected the development approval process. We, at this point, have a situation now where there is a significant case that has moved forward in Holiday. And we, in talking about the whole issue of referendum, we thought we would do that in a way of using as a case study what is happening here in Holiday. And as I mentioned, we felt like that by the time we have this conference, we would likely have a ruling from the Supreme Court, and we could talk about the implications of that. It appears that there will be some significant implications, particularly with this whole process that we've been talking about, with what's legislative, what's administrative, therefore what's referable and what's not referable. That's one issue, what's referable and what's not referable. The other issue that really seems to clearly come out in this, and it hasn't just been in this, but it's been demonstrated in other cases, and most particularly, I remember talking with Gary Crane about this back a few years ago when they had a referendum in the city of Layton. The process by which it went forward and what the city could and couldn't do, and the timing of everything, and it really seemed like it was not a process that was well designed, if you can use the word design, or well structured to actually get information out for the public in a fair and objective way, and the timing and everything that went along with that. And I remember talking with Gary, and he was saying, you know, this process just is not a good one. Well, we really haven't done a lot about it since then. So I think we're going to talk a little bit about that, and we have a good panel here to do that today, to talk about both the issues of what is and what isn't referable, and what is not good or what needs to change about a referendum process. Some have said, let's just get rid of the referendum process. Well, that would take a constitutional amendment. And our state Supreme Court has been very strong in voicing its acceptance of that state constitutional principle and saying this is the voice of the people and we're not going to mess around with it. So unless there is a constitutional amendment, it's here to stay. However, the state legislature does have the ability to design the process or make a process so that it could work more effectively. And so we're going to talk about that as well. So let me introduce quickly our panelists in the order that they're going to speak. First, we'll have Wade Budge speak. Wade is an attorney with the firm of Snell and Wilmer. And in this particular case study that we're going to be using in Holiday City, he has been working for and with the developer side on this issue and has some very interesting and very significant viewpoints and information about how this process is played out and what it means from the development and the developer standpoint, and as we go forward in growing our communities and developing our communities. After Wade, we'll hear from Todd Godfrey. Todd is with the law firm of Hayes, Godfrey and Bell. Todd is, of course, associated with Mike Mazarin. I knew Mike years ago when I was city planner for Centerville City. Worked with Mike very closely and just thought the most of him. Mike really did some interesting and some very good things with regard to land use and was a great attorney in that regard. And Todd is with that firm. And Todd represents the municipality of Holiday City and works as their city attorney and has, of course, the experience and the background now of what's occurred with regard to this referendum process from the municipal side. And will talk to us, I think, a little bit about some of the issues and problems that there are with how the process currently is structured and worked. And if we're going to make any changes to that process, we have with us Cameron Deal of the League of Cities and Towns, Executive Director of the League, and he'll talk to us about a proposed bill for the state legislature for this coming session in which we may indeed make some modifications or changes to that referendum process and how it works. So each of our presenters will take a few minutes. We'll have each one of them make their presentation, and then we'll throw it open for questions and discussion with you all. I'm guessing that many of you have some comments and some questions about this process as well. Wade?
Thanks so much, Wilf. It's good to be with so many friends and colleagues. I know so many of you in this room, and I respect a number of you. So I'll try to be brief enough so that we can actually engage in some audience participation today. I think one of the initial questions we can all ask ourselves is, why does this matter, this issue of referendums and initiatives? They go together. One of the reasons why it matters so much is that we have to always keep in mind that what cities and developers are working towards achieving is the right result. And oftentimes that involves a significant negotiation between the two groups to arrive at the right result where there's the right amount of gives, if you will, and the right amount of gets. And that is often dependent on, well, I can't think of when it's not dependent upon time. And what the risk is when you interject a referendum into that mix is that you add a new element of time that most projects can't handle. And what I mean by that is we all know how to handle a court challenge to a typical, like a CUP, a building permit, those kinds of things. There are processes that are followed, and the courts are well equipped to handle that. The problem you have with a referendum is you could literally put a project on an 18-month or longer burn before you would have a result. In other words, if projects now, as it's being argued in some instances, and in particular in the Holiday case, if the projects at even a more typical administrative level are now subject to a referendum, you could end up having projects put on a place where you'd be waiting for a municipal election before you know if it can go forward or not. So why would that matter? Well, you're going to hear me share a couple of points, and we are going to put up some slides. And I don't want anyone in the room to think I'm being hyper negative towards citizen groups who come and form and go after these referenda efforts. But I think there are two underlying things that we need to keep in mind, at least it motivates my actions and my interactions with my client, is number one, you have to keep in mind that citizens can have a very important role in land use planning, but that role has to be early and it has to be general. So I kind of view a citizen as having the role of electing good officials, and number two, they need to be involved and make their voices known when general laws are applied to an entire city. So if you're all of a sudden creating a zoning map, or you're all of a sudden setting zoning districts for an entire area, that's when they need to get involved in and if they think a mistake's been made, that's when they run a referendum. Because at that general level, you're not creating, you're handling these broad policy issues the way that these things should happen. If you get down and drill down to the individual site and you're trying to exercise your referendum right, then you create a whole host of issues, not only for the developer and the property owner, but also for the municipality. The second thing is that we have to keep in mind that when it comes to a third-party challenge, they do not own the property. What they have is a right to make sure they're involved in some sort of process. And again, it's best at the general level, but they don't have, for instance, a view easement. They don't have, any kind of property interest in the actual project that's being pursued. And that's why that's really important to keep in mind, because property rights still matter. And you shouldn't be able to try and achieve through a public process something you could otherwise go to the market and buy. So those are kind of some motivating factors that I think will help you understand why sometimes I take a dull view of people trying to use referendum power to stymie a single project. So where does it start? Wilf did a very good job of laying the groundwork. It starts with the Constitution. And the Constitution talks about two things, an initiative and a referendum, and about how both are available to the public. Now, it's interesting, when this was put into the Constitution, there wasn't zoning, right? So that's something to keep in the back of our mind as we're talking about this. But one thing that is true is that the courts have been saying, not necessarily always with the clearest words, but what they have been saying is that the referendum power may be used to challenge certain zoning decisions. So what are we going to talk about today? Where do we draw the line between what's zoning and what isn't? I think there's no dispute that when you're, for instance, zoning an entire city, that's zoning. When you're setting the zoning map, that's zoning. And when you're setting the boundaries of zoning districts, that's zoning. Now, when you go to the rest of the continuum and you get on the other end of it, like at a building permit or a subdivision plat or a CUP, where do you draw the line? And what we're here today to talk about is, in the way that the arguments have come out in at least a couple of these cases, there's enough out there in the statutes and case law for people to make arguments that the line should be a lot further over than any of us in this room, I think, would be comfortable with. So that's what we need to think about. Now, if you look up at the Constitution, what it does say is that it says repeatedly, three or four words together, as provided by statute, as provided by statute, as provided by statute. So the legislature very much has a role in making sure that any referendum power that's used by the people is done in an orderly way. And Cameron will go into that in greater detail in a little bit. But that's kind of just to orient us to the issue. The next thing that we need to keep in mind is there's this concept in LUDMA, the statute we all live and breathe and deal with each day, which distinguishes between what is administrative and what is legislative. Now, this has been an evolving definition. The definition I have up on the screen is the one that was effective as of this May. And what that definition clarifies is that when you've got a situation where a land use regulation, which means a zoning ordinance is being passed, that fits on what's called the legislative end of the spectrum. And when you've got something where it's initiated by the applicant, so if I go in and file an application for a permit, a subdivision, or an approval, that results in a land use decision, and that means it's on the administrative side of the spectrum. And so that kind of gives you a little bit of context. Now, where sometimes people will try to make things difficult is they'll then layer on the next statute which is involved, which is the election code. Election code doesn't always use the same terminology. It uses a little slightly different terminology, and as we lawyers often know, those variations are what we use to make our money, right? And the little different terms that aren't uniform from section to section. So when we get into the state election code, it's not as crystal clear, but it does talk about how an ordinance is a local law for purposes of referendum, a resolution, a master plan, and a comprehensive zoning regulation. So that is getting a lot closer to marrying what we have in the way of a definition in LUDMA, and I think what Cameron's going to talk about is trying to get those even a little bit closer so that there's better relationship. And then there is, of course, an exception down there about local law doesn't mean an individual property zoning decision. And that's something we had hoped we would have more clarity on by the time we got to today's meeting. But as of today, we were supposed to have a decision in the holiday matter by October 8th, but we are still waiting. So who knows? Everything we're going to say today could mean absolutely nothing tomorrow. That's just one thing I should have said at the very, very, very beginning. So, you might want to write your notes in disappearing ink because they might not matter. Anyway, so this is kind of giving you the current state of play as of today. One last thing, it also talks in the other section of the land use code about what is a land use law. Why does that matter? Because in the election code, there's a different percentage and there's different rules for processing a referendum involving a land use law. And again, this just gives you another example about how there are 3 or 4 different sections of this code that are all trying to arrive at the same result. And they're trying to take into account the fact that we've had a very evolved, not evolved to like a final evolutionary state case law. What we're talking about is a case law that is kind of all over the place. What I mean by that is the Supreme Court has been trying to confirm its thinking on this topic, and as a result, each time the statute is amended, it tries to take into account what the Supreme Court is saying, but the Supreme Court's precedents on this in this area are not clear. And so we'll see if that changes with the decision that's going to come out. It may not. And Todd can speak a little bit more about that because we were both at a hearing for 2 hours last month on this topic. And without meaning any disrespect, I could tell from a lot of the questions that there's a lot of confusion, even at the level of the highest court in the state, about what this means. They have some difficulty trying to navigate these terms and where's the right place to draw the line for this. So at any rate, that kind of sets the legal framework. Now, when you say, getting back to the initial question, why does this matter? How many of your cities have these kinds of zoning tools in your toolbox? Do you have MPDs? Do you have form-based code? Do you have master site plans? Do you have other development plans that involve large phase projects? Well, the reason why that matters is because that's the current battleground where this potential issue could raise its head. And you could have, if you have a neighbor group not happy, and if they're well-heeled enough to go and hire professional signature gatherers, you could have challenges in places you wouldn't have thought that challenges would have been available previously. So keep that in mind. And I think the most extreme example of how this could potentially play out is this. This is a plat we got approved last night in a city, and in green is marked a park. I could take the arguments that are currently pending before the Supreme Court and say that if you, as a city, were to move that green park between preliminary and final plat from one side to the other, that would be a referable decision. Now, no one in this room would think that would be a good idea, because when we're dealing with a plat, we're dealing with very quintessential administrative action. But unless we get some more clarity interjected into this statute and into the case law, then there's going to be the risk that people might be led down the path of believing things are referable that really aren't. So that's kind of the introduction. I'll kind of be quiet for a minute and let Todd offer some better perspective than mine, and then we'll hopefully get to some questions from the group.
Thanks, Wade. The lawsuit that's pending now, I wanted to give you a little bit of background on it. A lot of you probably know something about this, but it involves the old Cottonwood Mall site in Holiday. The city of Holiday was incorporated around the Cottonwood Mall property. And that's maybe just a little teeny bit of an overstatement, but not a ton. It was incorporated around, Lynn, 99 or 2000? In 1999. And the mall was the centerpiece of sort of the financial, it was the financial backbone of the city in a lot of ways. And around the mid-2000s, retail started to nosedive a little bit. The mall took a little bit of a hit. And the owner of the property wanted to redevelop the mall. Gateway was just coming online at that point. It looked like a great concept. And so General Growth Properties came to the city and presented a plan to redesign the Cottonwood Mall site. And in order to enable that, the city of Holiday adopted a regional mixed-use zoning text, a chapter of their zoning ordinance. And that is one of these sort of master development zones. And I think it's maybe a little more broad than a lot of what you see around the state right now in these type of zones. There aren't standards in this ordinance. The ordinance itself doesn't contain a height limit or floor. It doesn't have a density cap or floor. There aren't setback restrictions in the zone. There are no signage restrictions in the zone. So it's a pretty open template. And the way development was proposed to be accomplished through that was through a tool called a Site Development Master Plan. In my opinion, the general uses that apply to the zone, though they're not stated in the zone, were fairly well established by purpose statements. I know that's something people would say as legal practitioners, don't ever do that. But between the city's master plan, the site-specific master plan for the property, and the purpose statement of the zone, it was clear this was to be sort of a mixed use with a mix of housing types and fairly intense commercial development. It's titled regional mixed use. And the city adopted the zone and then a few months later approved a specific plan that was presented by General Growth Properties. And the whole project was supported by a redevelopment area, and they approved an agreement that shared tax increment funding to support the project also. That went unchallenged. It didn't go unnoticed, but it wasn't challenged. And right after that was approved in early 2008, we all got to late 2008, and everybody's world turned. You know, the economy completely tanked and everything died, and so that project was never built. General Growth went into bankruptcy. Howard Hughes Corporation ended up acquiring that asset out of the bankruptcy and held the property for a number of years. Over, I would say maybe 2011. Lynn, I'm looking at you because you may have a better gauge, but from 2011 through about 2016, they would occasionally rear their heads at the city and talk about something. It was sort of like, you know, a little touch here, a little touch there, but it wasn't really heavily engaged. Meanwhile, our elected officials were getting weekly calls, comments, questions, what's happening with the Cottonwood Mall? And in the meantime, the city's budget was suffering. You know, that was a significant part of how the city was planned, and it was gone. So the city's scrambling for other resources, they're patching things together, but the mall's not there. And around 16, Howard Hughes started to get a little more active. They brought in a few plans that the city didn't feel like they were really great. They didn't look that great. And as we were sort of talking with Howard Hughes Company about the nature of those plans and expressing to them, these really don't look great, they would say, oh, that's okay because we can't sell it anyway. You know, there were sort of projects that were designed around large anchors, couldn't find an anchor. They were showing pretty significant amounts of retail, a little reduced from the original plan, couldn't lease the retail. And when the city finally, you know, was saying, we don't like this, Howard Hughes said, well, we don't either, but this is the reality. What you have here isn't really a regional site anymore. The world's changed, retail's not the same, and the city had a lot of emotion invested in that site as well as plans, and it was really hard, and that was a difficult thing for that community. So we started to look more broadly at things, and then we got a fairly innovative proposal. And Ivory Homes, along with the Woodbury Company, convinced Howard Hughes to enter a contract with them to sell the property that was contingent on land use entitlements. They presented an original plan that drastically, and I'm going to be really candid about it, drastically reduced the commercial footprint. We went from, you know, a maximum of, was it 700?
Yeah, 700.
700,000 square feet of retail commercial space to where we were hoping to get in, you know, committed. Now there was the opportunity to do more, but the commitment to do commercial was 150,000, I think, in the original proposal. That's a lot different. With that, the residential development went up significantly. But as we started to talk with Ivory and Woodbury about the proposal, they had enough data and we had enough experience with the property to know that the old plan that General Growth had approved wasn't viable anymore in our new world. It just wasn't going to go. So we started to talk about the new plan. And it got to a point where we were able to get a defined amendment of the site development master plan, sort of the governing document, into a form to present to our planning commission. And we started to talk about how we would amend the development agreement to accomplish that. So the discussions were very serious. They were going, and I remember sitting in a meeting with Wade in October of 17, right, about a month and a half before the project was first presented to the planning commission, and we kind of said, what about referendum? And, you know, the initial thought was, we're not rezoning this property. The zone is what it is, it's staying what it is, we're not amending that zone. What we're amending is the executing plan. So most of you in the room who are attorneys or planners are familiar with the court's decision in Carter versus Lehigh. It's a 2012 case on referenda. It's not a planning case. But that's the one that sort of turned this referenda idea on its head in terms of the old analysis of the law. And when you look at that, what the court said in their analysis, and admittedly it has to be dicta because this was a case about taxing power or something. Yeah. It's not a land use case. But what they said in that case was, we're changing the way we analyze referendum questions now, and we're looking at it really as a truly constitutionally based right of the people. And when we do that and we give it parameters, we, the court, have to take on that role of determining what's legislative or administrative. Labels that we might see in ordinances or statutes might have some meaning, but we're going to decide what those things mean. And, oh, by the way, in the land use context, this whole idea of zoning being administrative doesn't fly. Those are legislative decisions. And they went so far as to say, you know, it's clear to us that if you're adopting the text of a zoning ordinance, that's legislative. Most of us, even under the old Maracas analysis, didn't question that. But they went so far as to say, if you're applying a zone to a piece of property, gosh, that kind of looks legislative to us. So when you look at our statute that defines a local law that is subject to referendum and it excludes the individual property zoning decision, well, you read Carter versus Lehigh and you wondered, and it wasn't any kind of a stretch, you wondered if they just put a red line through that, this, you know, doesn't apply to a local individual property zoning decision. That was problematic. And the court specifically said, look, here's some easy cases. The adoption of zoning text is easy, but the conditional use permit is also easy. The variance is also easy. Those are clearly administrative. What might be difficult is that more kind of gray area individual property zoning decision. And then they adopted the, is it Cresci? Sarah, Carol, are you still here? Do you remember how do you say that name?
Oh, yeah,
Crikey, thank you. Just so you know, the Supreme Court says it Cresci, but Crikey. In that Saratoga Springs case, the court said, you know what? That individual property rezone, that's legislative. And we did, you know, that's horrible. That's a real game changer. And so when Wade and I were thinking about our project and the nature of it, and Holiday's specific processing and requirements, that question came up. And as we thought and toiled and wondered if there's something we could do to give more predictability to whatever entitlement might come out at the end of the process, I'm telling you, we didn't come up with anything other than the way we did it. And we're sitting in the Supreme Court now waiting for a decision that hasn't come yet. When the referendum actually came in, we did all the normal things. We wrote the letter to the sponsors that says, okay, thanks, here's your signature packets. Oh, by the way, we're not really sure this is a legislative question. We're not sure it's qualified for the ballot. We're sort of letting you know that if in fact we determine this is administrative, no matter what happens with your signature gathering, we won't be putting this on the ballot. And we sent them out with their packets. And it didn't take them long. It was inside of the 45 days, they came back with a sufficient number of signatures. And the heightened land use law requirement is 35% of the votes cast for governor in the last election that elected a governor. They had to have 5,800 signatures in Holiday. They came back with mid 6,000, so they met the requirement. It wasn't difficult for them. So at the point those came back, we made our final evaluation, and Holiday's ordinance has a specific provision on the amendment of a site development master plan. And in our land use table, we have a table that characterizes the nature of different decisions the city makes, and it characterizes the amendment of a site development master plan as an administrative approval. And notwithstanding the questions we had, the nature of our process, the gray area, everything else, it's pretty clear you better ride the horse that brung you. And our ordinance was the horse that brought us, and we needed to be consistent with it. So looking at everything, understanding the gray area, and I personally had a commitment that I felt like the better arguments long-term from a policy perspective supported this determination being declared or characterized as administrative. That's the decision the city made. We notified the sponsors we weren't going to put this on the ballot. And then we had a major issue. Time is a problem. Wade talked about that. But in our specific case, because we had a contract for purchase, and we don't know all the details of it, but we knew there was a contract to purchase the land. Our applicant and the folks who we took through the process aren't the owners of the property. They're their agents, but they don't own it. We knew time was an issue, and that if delay pushed this out long enough, they would lose their contract right, and we'd be back in another process again if we were fortunate. And the development of this property means something to the city. It was significant. So we tried to look at it and find a way to assure that the decision that came out of the court would come before a November election date. The city would have to declare a special election if it got to that point. We'd said we weren't going to put it on the ballot, but if a legal challenge came, we wanted to assure that the question would be answered in 2018 and not push into 19. And we had, as we looked at it legally, almost no control over that process, because the initiative sponsors are the ones who are filing their lawsuit. There's an emergency writ right to the Supreme Court, but the Supreme Court's precedent makes it clear that they consider that sort of a maybe we'll take jurisdiction and maybe we won't. It depends on the nature of the question presented. More often lately, they have forced that question to the district court. A district court's decision, as you know, it's great and it's powerful, but it's not final if there's an appeal right that's still out there. So we were trying to make sure we could generate a process that would get us to a decision before Election Day. We're sitting here today still hopeful, but we don't know what's going to happen. So that's sort of where the case came down. The arguments that have been presented to the Supreme Court really are addressing the gray area that Holiday's ordinance, I think, raises specifically, but that I suspect a lot of you have in your cities. And we are arguing that our action is administrative and should be characterized that way for a number of reasons. But we have invited the court to draw a very bright line on the did you change the zoning designation of the property. We have asked them to do that. Any of you who are lawyers and have looked closely at the court's precedent, when Carter versus Lehigh came out, they looked at sort of a couple of areas that they said were hallmarks of legislative action. One was the weighing of broad policy considerations, and the other was the general applicability of the action. Later in Carter versus Lehigh, and then in Krecky, hope I said that right, Sarah, they made a determination that that general applicability prong is satisfied if a land use decision runs with the land.
Let me just put my head in my hands.
And that is really, really troubling, because those of you who are hardcore land use practitioners, when you think about decisions that run with the land, it's really clear that a conditional use permit, which the court has already characterized as quintessentially administrative, always runs with the land. A variance always runs with the land, and usually is recorded against the property. Subdivisions run with the land because they're platted in the county records. That's what runs with the land. So this idea that, that's a hallmark of legislative action is really troubling to us. When we got to that point at the city of realizing we've got a problem trying to get through quickly and we've got real thorny legal issues, we made the call to engage the firm of Zimmerman Boer to represent the city. Those of you who don't know Troy Boer, if you ever get in a nasty kind of a legal pickle where you're going to have appellate advocacy needed, boy, I can't recommend them highly enough. They were masters at working through the procedural process along with Wade and Alan Sullivan, who were terrific. But in going through that whole analysis, Troy stood up pretty boldly before the court and said, "You've got this wrong. You've got to fix this." So we're sitting back now waiting to see what a decision looks like. If they bite on the invitation to draw a bright line, we certainly hope it's the right one for our perspective in this case. But we have so much that's, really thorny and tough about this. And we're just hoping for a decision before our election day. So.
let me take a step back and talk about the policy, the overarching policy that's really at stake here, and more importantly, what it means for an individual voter, a property owner, and a city. So let's just look through the calendar from October 24th today until November 6th on Election Day. If the court tomorrow determines that this was an administrative act by the city, because ballots have already been mailed to residents, and residents have already filled out the ballots and sent them back, there will be an election result that will be a non-binding opinion question about the future of the Cottonwood Mall site in Holiday, even though it should not have been on the ballot in the first place because the court would have determined that it was administrative. Talk about an impossible situation for future elected officials, particularly those who have to stand for election next year in Holiday, because of the timing of adjudicating the referendum piece. So then, like I said, let's talk about the overarching policy piece, setting aside the fact pattern and Holiday specifically. And I want to really focus on the clarity of the process and the overall timeline of the status quo of referendum on the local level. Let me be clear, I'm not talking about the state referendum process, which is independent. And then also the balance of information in the public sphere, because that's a critical piece to this conversation as well. Out of curiosity, how many of you have experienced a referendum firsthand? Hold your hands up high, okay? And if you haven't, I hope you're taking notes, because unfortunately, you likely will experience referendum at some point. Right now, there are 1, 2, 3, 4 of us up here, and then we pick up another friend. Let's say we take Peter Caroon here, who there would be some great irony, actually, now that I think about it, of having you file a referendum against a legislative act, but let's just, for conversation purposes, do it. The 5 of us go into the city to refer an act. Now let's remember what that underlying premise is. When the 5 of us go in to refer an act, we are referring the official legislative act of elected officials. So people who've been elected to make these decisions, and we are the check. The 5 of us are trying to start the process to be a check on the power of those legislative representatives. That also begs a policy question that I'll come back to, which is what should the right be of those duly elected officials to respond to the referendum? Okay, so file that away, I'll come back to it. The 5 of us go in to the city of Xanadu. I don't see Jody here, unfortunately, but we file our referendum against the city of Xanadu. The time frame starts, and we have a period of time once the city gives us our signature packets to go out and collect signatures. During that same time frame, the city attorney, in this case it can't be Todd because he's one of the petitioners, so I'm going to pick on you, Gary. Let's say Gary is the city attorney for the city of Xanadu. Gary is putting together, by law, state law requires Gary to put together the legal analysis of what the referendum will mean. At the same time, let's say Roger Baker here is no longer an attorney, you're now the finance director for the city of Xanadu. You're putting together the fiscal analysis of what the referendum means. Both of these documents that the state requires the city to put together are being put together simultaneously to the 5 of us going out to collect signatures, and the clock is running. And the time frames don't match. So the fiscal analysis and the legal analysis have to be done in 25 days. We have our 40 days to go out and collect signatures. And even then I should put a little asterisk because it depends on whether or not it's a truth and taxation referendum or a land use referendum. For this conversation, we're setting aside the condensed time frame for truth and taxation and just focusing on land use. But when that analysis gets done, who receives that analysis? Under state law, only the 5 of us. So thank you very much for your work. Wow, this is going to cost the city of Xanadu this much money, or you think it's administrative? I don't think I'm going to share that when we go door to door to collect signatures. Thanks for your work, though. I appreciate it as a taxpayer in the city of Xanadu. Well, now you see one of the disconnects in the overall process and trying to make sure that there's accurate information for an informed electorate. Wade was right and you saw the slide, that the constitutional authority to refer a legislative act rests with the people. We're not talking about eliminating that constitutional provision. What we're talking about is improving and modernizing the process so that you have an informed electorate, and that the information that the city of Xanadu has created about the fiscal impact and legal impact actually gets to the people before or when they are signing the petitions, and when they are ultimately making a decision if it gets to the ballot. Now, we've been talking about the difference between a legislative act and administrative act. The power of the people is legislative, it's not administrative. So what happens when Gary Crane, sitting down with those elected officials in the city of Xanadu, determines, like in Holiday, that it's an administrative decision? Under the current process, that decision does not actually get finalized until the 5 of us come back with our signature packets and the county certifies the signatures. So by then, thousands of residents have already signed and already have a vested interest in the outcome of what may be a non-existent referendum. When we talk about trust in government and trust in elected officials, the worst possible outcome for residents to trust their elected officials could be what happens in the next couple of weeks if this turns into a non-binding opinion question in the city of Holiday and people have already cast their votes. Back in October of 2016, we sat down with Representative Brad Daw because he'd opened a bill file. It was House Bill 20. And this initial bill only focused on the communication of elected officials. So now let me leave the process piece for a second and come to the communication piece. Representative Daw was frustrated because of what had happened in Provo and Orem. And do I have anybody here from Provo and Orem? I know Provo was picked on earlier today by Clark unfairly. Okay. And so, you know, I texted Wayne Parker immediately to let him know about what Clark was saying about Provo. Provo and Orem, 2 different forms of government within the municipal world, both were facing citizen referendums about agreements with the Utah Transit Authority. And UTA, as we know, is a 4-letter word, particularly in Utah County, but for these agreements with UTA about the bus rapid transit line. And Representative Daw was frustrated because he felt like once the 5 residents had gone into Orem City and Provo City to start this process, that should have put handcuffs on the ability of the mayor at the time, John Curtis, and his staff, and the elected officials on the city council, and Mayor Brunston Orem and the city council and senior staff should have put handcuffs on their ability to communicate with residents about that referendum. So his original proposal in House Bill 20 would have clarified that the provisions in the law now that say once there's a ballot proposition, the only communication that can happen from the city using public funds, using the only expenditures from public funds, can be for a brief statement, which is undefined, and factual information, so long as you provide it to both sides, equal access to both sides. In addition to that, you have the voter information pamphlet, and that's really it. So Wade mentioned you have LUDMA, and then you have the election code. This is the election code plus what's known as the Political Activities of Public Entities Act, which was passed just, I guess, 4 years ago now. And really, these are my terms, puts the handcuffs on public officials and public entities from being able to communicate with residents about ballot propositions. Now, there's a policy question right there over whether or not it's appropriate. Okay, and I'm not trying to answer that question per se, because the Political Activities of Public Entities Act is what it is at this point. But the argument that we took to Representative Daw back in October of 2016 was we need to have this policy discussion over whether it's appropriate for an elected official who's cast that vote that's being referred to be able to articulate why he or she cast that vote. Likewise, when voters call the city and say, tell me more about this referendum, I've had signature gatherers come to my home, tell me what this is about, that city staffer should not face a fine if he or she responds to that question. And particularly in the era of social media and misinformation being spread. And this is one of the benefits and pitfalls of free speech. And we're not trying to limit free speech, but just trying to ensure that there is equal access and in the most informed electorate possible throughout that referendum process. And we then also explained to Representative Daw all of the problems with the timeline in the local referendum process. And to his credit, he agreed with us. Press paused on House Bill 20. We put together a working group last interim that then resulted in House Bill 225, and I want to give a shout out to the House of Representatives because the House of Representatives passed House Bill 225, and then it failed on the last day of the Senate. And it would have addressed the timeline piece, it would have addressed some of the signature thresholds, and then this one critical piece it would have addressed on the legislative administrative piece. And it's what we refer to as the pause. I mentioned you have these two timelines moving simultaneously. What we recommended to Representative Daw, and he embraced it, was that when the five of us walk into the city of Xanadu and file that petition for a referendum, that the clock for signature gathering does not start. There would be a pause, and during that pause, Roger and Gary prepare the legal and fiscal analysis. The statements for and against the referendum are also prepared by the respective parties. And most importantly, the adjudication of whether or not the act is legislative or administrative happens during that pause. That way, before emotions get riled up, before signatures get gathered, and before you have this false expectation in the community, you actually adjudicate upfront whether it's legislative or administrative. And there would be an emergency recourse right to the Supreme Court with a time frame so that we could get it resolved quickly for the reasons that Wade and Todd indicated. You get that decision made early, then you open it up to the election process if it's legislative, but right now the process is backward. The last piece, coming back to the communication side, that we tried to address was making sure that elected officials and city staff had the ability to respond to questions. Ultimately, what we don't want is a situation where residents feel like their elected officials or their city leaders are incompetent or unable to respond to questions about what's happening in their community. So we were trying to address that piece as well. The last thing I'll reference, and we'll open up to questions, is the actual process for getting on the ballot. For a state referendum and a state initiative, and we have 4 initiatives on the ballot this year, as you know, you actually have to go through a process where you don't just hit a threshold quantity of signatures. You hit a threshold quantity with a geographic component around the state. And it's slightly different for initiatives and referendums at the state level. We suggested a similar process that you would have the threshold. You heard Todd reference what the current standard is under state law, and it actually looks at voter turnout from the most recent presidential election. Well, let me give you an indication of how that can widely vary in the state depending on turnout. Senate District 1 in 2016, I've got the numbers right here. There were 17,816 votes cast. So if you had just a 5% threshold of 17,816, that 5% would be 891 voters. Senate District 10, which is also, both of those are in Salt Lake County. They're about 7 miles apart. Had voter turnout of 37,419 in 2016, which means a 5% threshold would be 1,871 signatures. So you would need twice as many signatures in Senate District 10 if that were the city of Xanadu than you would in Senate District 1 if that was the city of Xanadu. So what we recommended was changing the threshold from looking at the presidential turnout and instead basing it off active voter. That way, you're using the same data point regardless of where the city or the county is located in the state. And then you would have a geographic component as part of it. So in the city of Holiday, for example, there are 6 council districts. And so our recommendation to him was saying that you need to hit a threshold and then have a minimum baseline in the majority of the council districts in Holiday. Now, for the city of Orem, all of their council members are elected at large, and so the district model doesn't work, but we recommended some other ways to try to have that geographic diversity. That way you have participation throughout the city from the electorate as you move forward in the signature gathering process, rather than maybe just one angry bunch of people in one section of the city. We also were looking at ways to try to address the false campaigning and misinformation that occurs. I'll pick on Gary for a second, my city attorney of Xanadu, but in his day job, he's the city attorney of Layton. And when Layton faced a referendum several years ago, there were documents distributed that looked like official tax notices that were fraudulent, but were spreading misinformation about the referendum. And so we were looking at that piece of it as well. So it was a complicated bill, failed on the last night of the session, and we plan to bring it back, but we're in a holding pattern until after the holiday situation gets resolved.
All right. Thanks so much to our panelists. We only have a few minutes left, but we'd like to open it up for some questions if there are any.
How would that bill address unincorporated county areas where the land use code or flood has only put the unincorporated? Would it require the full electorate
Oh, I see.
to address the issue?
Countywide. Yeah.
So under House Bill 225 as it was drafted, and I'm going to put words in your mouth and reference Olympia Hills, that Olympia Hills would have needed to, or referendum organizers would have needed to hit a signature threshold based on the entire county's population, not just the unincorporated county's population.
Other questions? Any other questions or comments? Come on, I know you've got some, right?
Let me
No.
just give you one thing that might cause you some concern. We had Bruce help us on the amicus brief. That shouldn't cause you concern. That was helpful. But one of the things that Bruce said is if you don't get this line drawing right, then you could have an initiative where you go and try and have a site plan imposed on a city and on a property owner by citizen group. Because the other side of this referendum initiative coin is the initiative process. And can you imagine having citizens band together if the court doesn't get this right and impose that, subdivision plat on a city and go ahead.
So I can envision it because it happened to me. What I had happen was a band of citizens that got together. They realized they couldn't do a referendum, so they tried to do a retroactive initiative. So an initiative that would have retroactively denied a project that was already approved. And we told them that it was unconstitutional, and they told us the legislature can pass unconstitutional laws, so can we.
Well, guess who gets to pay for the taking on that? It's not them. Yeah.
Exactly. So, I mean, there's been a lot of focus on referendum, but there are a lot of similar but different issues on initiatives.
Where was this located? Where?
That was down in Canab.
That was,
Oh, in Kanab, okay.
His former life.
Yeah.
Is anyone
And-
here from Orem?
Well, and just quickly on the initiative deal,
Both.
before you get to that, Cam, there was an initiative back, a number of years ago in Sevier County to change their local zoning or land use code with regard to power plants, where you had a group of citizens that were opposed to the proposal of a new power plant that would have severely restricted the construction of any new power plants, and they actually proposed a new ordinance. I think ultimately either didn't go to a vote or wound up failing, I don't remember which. But so that can happen. Sorry, Cam.
And, to follow up on David Milheim's comment, what we're trying to avoid is really becoming that. Dave, that slide we added after your comments.
Part of the reason I mentioned Orem is that there is signature gathering going on, and I don't recall where it's at in the process, but there is signature gathering going on for an initiative about the land use code there in particular, or with regard to housing and high-density housing throughout the city. That was spawned out of frustration with a proposed project adjacent to Utah Valley University.
Well, so they do have something on the ballot.
So the initiative is on the ballot.
Right.
Okay, so there you go.
Yeah.
And that's not a referendum, that's the initiative that was gathered by the citizens.
We're about out of time. Let me just give you a quick quote to end the session here. This comes from The Economist magazine in 2015, where they talked about referendum or referenda in general, and they were talking about more national referendas or large regional referendas, and as they took place around the world. But one particular quote out of that article struck me as particularly appropriate, because when you think about who usually files for a referenda, it's usually citizens in your community who don't like something that your elected officials are doing. And generally, your elected officials are trying to, in essence, change something, right? Something new, a new ordinance, a new zone, a new development proposal. And the quote out of The Economist on referenda said, "One thing most referendums have in common is that they tend to deliver victories for the status quo." And so that's something to kind of keep in mind as we go forward in this process, just to give you a little bit of perspective on it. Thanks to our panel. Thanks to you all for being here and listening. And we'll move on to the next session.